This is Michael Popok, Legal AF. I forgot how much I missed Judge Chutkan in the D.C. election interference case. She's back. She's cranking out orders against Donald Trump almost hourly to clear the backlog of motions he filed, some going back all the way to October, 9 months ago. And she's just denying the motions now that she's got the case back. Remember that case against Donald Trump for the 4 counts of election interference and for obstruction of an official proceeding and defrauding America was put on ice, was stayed while the Supreme Court of the United States finally got around to deciding on July 1st about the immunity decision. But they sent it back to her. This is the first week and weekend that she has the case back officially. And boy, is she chopping wood. There were 4, for instance, motions to dismiss, all filed on the same day in October the 23rd, that Donald Trump filed to try every which way to get rid of that indictment against him, that pesky little thing called an indictment from Jack Smith, the special counsel. And now, in the course of just hours, she's already denied 2 of them. And I'm sure the next 2 are on the chopping block. Earlier today, and I did a hot take on this one already, she dismissed the argument that the indictment should be dismissed on what's called statutory grounds. In other words, Donald Trump had argued in October that the 4 counts of the indictment, and in a motion to dismiss, they all have to be accepted as true. All the facts that were alleged by Jack Smith have to be accepted as true, that they didn't state a claim for the actual crimes. The judge says, I am denying that without prejudice while I decide on the immunity issue. But today, in a scathing order on the heels of that, she's denied another motion to dismiss Donald Trump brought. Donald Trump brought a motion arguing that he was the victim of selective prosecution and vindictive prosecution by the Department of Justice, that they were just doing President Biden's bidding. That's the only reason he's being prosecuted, and the whole case should be thrown out. His entire basis for that was a couple of Washington Post articles and his own Truth Social postings. Not evidence, not statistics, not testimony, not sworn, not recordings, not videos. Newspaper articles and his own self-serving social media postings. And the judge called him out. She started her memorandum opinion, which goes on for 16 pages, by saying, we're back. The United States has charged former President Donald J. Trump with 4 counts of criminal conduct, which is alleged to have committed during the waning days of his presidency. First thing she took him to task for is what he does over and over again. He tries to recast the allegations against him, downplay them, and minimize them, and she's having nothing of it. Here's what she said on page 1 and page 2. She said, at the motion to dismiss stage, I have to accept all of the allegations of the indictment as true. And then she says, at the outset, this is on page 2, the court must address, as it has before, defendant's improper reframing of the allegations against him. He declares that the indictments amounts only to a government, quote, theory that it is illegal to dispute the outcome of an election and work with others to propose alternate electors. He took that entire indictment and said, that's all I'm being prosecuted for. I'm just working with some other people, trying to come up with an alternate slate of electors and just objecting to the election. Really? The judge said, that description mischaracterizes his alleged conduct. She goes on to say, defendant is charged with knowingly making false statements in furtherance of criminal conspiracies and for obstruction of election certification proceedings, and cites the indictment. Judge Chutkan then says the indictment does not charge defendant for publicly disputing the election outcome and merely, quote, working with others to propose alternate electors. Indeed, and then she quotes from the indictment to smash it back, an overhead smash back at Donald Trump. She says, read the indictment. The indictment said defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He's also entitled to formally challenge the results through lawful and appropriate means. She said, but that's not what the indictment says happened here. Let's move on. She frames it this way, as every judge handling a selective prosecution or vindictive indictment, vindictive prosecution claim must. She said there's a 2-part test, and Trump has not met either of the 2 claims. First, he has to prove that there is a discriminatory effect. In other words, there are other similarly situated defendants or people who did similar things as Donald Trump is alleged to have done, and they were not prosecuted. In other words, he's got to come up with what's called comparators, people that his conduct can be compared to, and said, see, that guy did the exact same thing. So, in other words, what is the comparator for Donald Trump? The judge says there isn't one. You have not cited to me a former or then president who, as the indictment alleged, went out of his way to lead a conspiracy in order to cling to power, including the use of fake electors, including a pressure campaign against election and elected officials to get them to do his bidding, and the weaponization of the Department of Justice. Now, look, some of those allegations may not survive the United States Supreme Court decision on immunity, but most of them will. And what the judge here is saying is, you have not provided me with any comparator to you and your behavior to pass the first prong that's required. You have the burden here in order to dismiss on this grounds. And so we have that. And she said and reminded Trump that it is very unusual for courts to interfere with the executive branch's exercise of their prosecutorial function. That's sort of a shot across the bow at Judge Aileen Cannon down in Florida, who has no problem continuing to interfere with the prosecution's indictment, in fact, dismissing it. She doesn't mention it by name, but I think that was a pot shot at Aileen Cannon. Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's TRYFUM.com, and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today. She also says, look, let's look at your evidence. Your evidence is, this is on page 3 of the order by the judge. He claims that under selective prosecution, defendant claims that public statements by President Biden and news reports sourced to government personnel with direct knowledge are prima facie evidence that this prosecution is selective and vindictive. And then attaches Washington Post article, a New York Times article, and his own Truth Social post. The court says, I cannot agree with that. That's on the bottom of page 3. As to the second part of the two-part test, she says that Trump, under the law, and there's a leading case in the D.C. circuit called Rosati, under the Rosati test, a defendant must show that the prosecution was also motivated by a discriminatory purpose, meaning even if he could find, there was an exact person like my alleged conduct and my position and my title and my high office that wasn't prosecuted, even if he found that, you still have to show it was motivated by a discriminatory purpose, which means, she says, you have to show by direct evidence or evidence concerning the unequal application of the law, statistical disparities, or other indirect evidence of intent. And then she peels it back. She said his entire evidence of discriminatory intent is a conclusory single paragraph of legal conclusions that she's already rejected in the past. She said Trump's main contention on page 5 is that other people have committed the same conduct without being prosecuted. But the court has already explained to him that, quote, defendant is not being prosecuted for publicly contesting the results of the election. He's being prosecuted for knowingly making false statements in furtherance of, this is on page 5 over to 6, a criminal conspiracy and for obstruction of election certification proceedings. So she says your whole analysis is wrong, and therefore your purported evidence of the newspaper articles are a complete misreading. She basically says to Trump and his lawyers, you can't even read. On page 7 over to 8, she says your reading of the Post articles, the New York Times articles, is a complete misreading and a contortion of what they are stating. It's not evidence of discriminatory intent or discriminatory effect at all. So she is saying that there is nothing in the evidence provided by Donald Trump that shows that President Biden urged Attorney General Garland to take decisive action against the defendant. She says on page 8, at most, the Times article reports that President Biden privately commented on one occasion that he believed President Trump should be prosecuted. And on one separate occasion, he wished the Attorney General would act more like a prosecutor who's willing to take decisive action. There's no indication that Biden ever expressed any such comments to the Attorney General or the Justice Department, much less that such comments actually resulted in politically motivated action. That's the difference. And since Trump has the burden, he has not met his burden. She also says he misstates the timing of when the special prosecutor was appointed. He says, well, it was obviously appointed because Biden wanted to win the election. She says on page 9, Merrick Garland made clear that the appointment of the special prosecutor, in his mind, special counsel, was because Biden had announced that he was running for re-election, and therefore they wanted to take away any kind of impression that the Department of Justice was biased. It's the exact opposite of what the reason for the special counsel is, because Merrick Garland, in the abundance of caution, did not want to be prosecuting a case directly through Maine Department of Justice, when his boss was running for re-election. Because Donald Trump always turns facts upside down because he lives in an alternate universe where he's completely unmoored from planet Earth or from facts. And that's what the judge has concluded. So she has denied in a scathing 16-page decision. And look, let me talk at the end of this hot take about what this means. The language that I'm picking up with Judge Chutkan now in back-to-back orders, and I expect, because there were 4 motions to dismiss filed on the same day, October 23rd, 2023, 9 months ago. She's now back-to-back denied 2. We just got another one here over the weekend. I expect she's going to deny the motion to strike allegations of the indictment on inflammatory allegation basis, and that she's going to get rid of the motion to dismiss on constitutional grounds. So what she's doing now is clearing the brush. She's clearing the backlog of prior motions, but the words that she's using, as scathing as they are, in rejecting Donald Trump's principles, means for me that when she gets the issues briefed in front of her on whether the immunity decision for the United States Supreme Court eliminates all or most of the indictment, she's not going to find that. The way she has properly framed the indictment, I see it already. She's already kind of drawing a line in the sand and almost being very protective over the indictment, which she has to assume is true, the allegations of it, for the purposes of these motions. Now, she's going to take this immunity decision from July 1st from the United States Supreme Court. And over the course of August, maybe into September, through briefing of the parties on both sides to get the facts, to get the law, and maybe with an evidentiary hearing, she's going to make the ultimate decision if Jack Smith's indictment survives, or if it has to be dismissed because of immunity. There is, based on these rulings, which I think is a bad harbinger for Donald Trump, he is going to lose ultimately, and this indictment is going to survive at least Judge Chutkan. Now, the loser of her decision is going to try to take another appeal to the D.C. Court of Appeals and ultimately to the United States Supreme Court. So the timing here, which for me is becoming less important as it looks more of and more likely than not that we're going to be swearing in Madam-elect President Kamala Harris, But I don't think this trial is going to get up and running. I'm sorry, the ruling by the judge affirmed on appeal until kind of the late fall between the election and the inauguration. We'll continue to follow it all. And Judge Chutkan's sort of midnight rulings here to catch up on her docket now that she is back in charge and has regained and reasserted jurisdiction over the case against Donald Trump on the MeidasTouch network and on Legal AF. We're so close to 3 million free subscribers. Just go and hit the button free if you like the content here and help us build this independent network without outside investors. And then follow me on Legal AF on Wednesdays and Saturday nights at 8 p.m. Eastern Time, where we live record, and then on audio podcast platforms, plug in Legal AF. Then I do hot takes like this about every hour on the MeidasTouch network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.